Welcome to a new episode of our podcast dedicated to regulatory affairs and life science. In today's episode, we will talk of Article 16 of the MDR and IVDR and see when a distributor or importer becomes a manufacturer. A distributor, an importer, or any other subject making any change in a product already put on the market may, in some cases, assume the legal qualification of manufacturer. Regulations EU 2017-745, the MDR, and 2017-746, the IVDR, on medical devices and in vitro diagnostics provide for a specific article aimed at clarifying the circumstances where this case may occur. For both legislative texts, the article in question is number 16, outlining 3 cases when a distributor, an importer, or any other natural or legal person assumes the obligations incumbent on manufacturers. 1. If they make available on the market a device under their name, registered trade name, or registered trademark. 2. If they change the intended purpose of a device already placed on the market or put into service. And 3. If they modify a device already placed on the market or put into service in such a way that compliance with the applicable requirements may be affected. Article 16 also lists special situations that are exceptions to these cases, where the economic operator is not bound to assume the obligations incumbent on manufacturers. Exceptions to Case 1. Although making a device available on the market under their name, registered trade name, or registered trademark, an economic operator is not considered a manufacturer in 2 of the following situations. If the person, while not considered a manufacturer, assembles or adapts for an individual patient a device already on the market without changing its intended purpose. If a distributor or importer enters into an agreement with a manufacturer, whereby the manufacturer is identified as such on the label and is responsible for meeting the requirements placed on manufacturers in the regulation. Exceptions to Case 3. 2 special circumstances are not considered to be a modification of a device that could affect its compliance with the applicable requirements. The provision, including translation, of the information supplied by the manufacturer in accordance with Annex 1, Section 23 of the MDR or Section 20 of the IVDR, relating to a device already placed on the market and of further information which is necessary in order to market the device in the relevant member state. The changes to the outer packaging of a device already placed on the market, including a change of pack size, if the repackaging is necessary in order to market the device in the relevant member state, and if it is carried out in such conditions that the original condition of the device cannot be affected by it. However, in the case of devices placed on the market in sterile condition, it should be presumed that the original condition of the device is adversely affected if the packaging that is necessary for maintaining the sterile condition is opened, damaged, or otherwise negatively affected by the repackaging. Therefore, the economic operators carrying out these 2 activities remain distributors or importers. However, Article 16 provides for some additional obligations to those already incumbent on such economic operators. In particular, distributors or importers are bound to indicate on the packaging or in a document accompanying the device the activity carried out and their own details. Have a quality management system that includes specific procedures which ensure that activities are performed in compliance. Carry out the following operations at least 28 days prior to making the changed device available. Inform the manufacturer and the competent authority of the member state in which they plan to make the device available, and, if requested, provide these subjects with a sample of the modified device. Submit to the competent authority a certificate issued by a notified body designated for the type of devices that are subject to such relabeling and repackaging activities, attesting that the quality management system of the economic operator is compliant to carry out these activities. Although Article 16 outlines the cases described above, the legislative text only provides general indications. To understand the impact and the consequences of a change in a device already placed on the market on the legal role of the economic operator that performs it, a careful case-by-case evaluation is required for the operation to be carried out. In case the person performing such change remains a distributor or importer, an interaction with the manufacturer is often still required. The Renzo Regulatory Affairs can support distributors and importers in the evaluation of the implications of the change they wish to perform in a product already placed on the market, and can also help manufacturers to understand whether such changes affect their own technical documentation. Thank you for listening to today's episode. If you want to listen to other podcasts, sign up for our channel, follow up on the social media, and join us for next episode.